Welcome to the Deep Dive. Today we're taking a long, hard look at a really complex issue.
A very complex one.
It's that intersection of international marriage, divorce, and child custody. And we're going to focus specifically on a controversy that has, for years, put Japan at odds with much of the world.
Right. It's where these deeply personal family issues crash right into international law.
Exactly. And the legal systems that govern our lives, they rarely clash as violently as they do when an international couple divorces and one parent takes the children across a border.
It's a legal minefield.
It really is. We started pulling these sources together after hearing this fascinating but also deeply unsettling story.
Oh, the one from the flight.
Yeah, the chance encounter on a flight to Trieste, Italy, maybe a little over a decade ago. A researcher was sitting next to this man, an Asian professional, and his entire world was just binders and legal paperwork.
Wow.
He was getting ready for what he said could be a decade-long, cripplingly expensive multinational custody battle.
A decade. That's just unimaginable.
But the thing that was so surprising, the real nugget of knowledge we got from that conversation, is the core of what we're exploring today.
Which is?
It was just how fundamentally different national definitions of parental custody are. For this man, just being the father wasn't enough. He had to spend years, a fortune, flying overseas to argue his case in a foreign court that saw his basic rights completely differently.
And that story, it just frames the dilemma perfectly. You mix different legal systems and a painful domestic divorce, it just explodes into this multi-jurisdictional war.
It really does.
And the strain on the parents is often, secondary to the strain on the child. The kid is stuck in the middle, facing cultural isolation, language barriers, just being pulled between two worlds.
So our mission in this deep dive is pretty clear.
I think so. We need to analyze exactly why Japan's historical custody laws have drawn such intense international condemnation. We'll explore the current flaws in the system, especially for victims of domestic violence, and then we'll get into the implications of these huge legal reforms that are finally scheduled for 2026.
Okay, let's unpack this. We started with the story of a father fighting for access, but when you start researching, you very quickly find the more widely reported issue, and that's the criticism directed at Japanese women for what foreign governments call child abduction.
Or, as it's often framed in Japan, child-led separation.
The collision is so stark. One country sees it as a mother protecting her child, the other sees it as kidnapping. But why does this happen so often in cases involving Japan?
Well, the problem isn't usually, malicious intent. It's really rooted in two fundamental systemic structures in Japanese family law that have been around for decades.
Okay.
The first is Japan's long-standing adoption of single-parent custody after a divorce. This is pre-2026, of course.
So joint custody just wasn't even on the table.
Not an option, exactly. And the second factor, the one that really compounds it, is the cultural and legal reality that mothers get custody in about 90% of cases.
90%.
So if a Japanese woman returns to Japan with her kids, she's almost guaranteed sole custody under Japanese law, even if that very act is considered international child abduction in the country she just left.
She's legally protected in Japan for something that could be a crime somewhere else.
Precisely. And this is where the legal systems just violently collide. The consequences are immediate, and they can be severe.
We have some really specific, memorable examples of this backlash. Our sources point out that Japanese women have actually been placed on the U.S. FBI's official parental kidnapping list.
That's serious.
Very. And to show how severe it can be internationally, one Japanese woman actually received a prison sentence in France for taking her child back to Japan.
A prison sentence?
Yeah. The cultural gap seems huge. For many Japanese mothers, the thinking is just, of course the child stays with the mother. Taking the child is seen as a way to ensure stability.
But that action clashes directly with the joint custody frameworks in the U.S., Europe, Australia.
And then that removal becomes a criminal offense.
We saw a really high-profile modern example of this with the celebrity table tennis player Fukuhara Ai.
Right, I remember this case.
She unilaterally removed her child from Taiwan, which is a jurisdiction that uses joint custody. Taiwan said her action was illegal.
And the key part here is what happened next, right?
Exactly. The Taiwanese legal action resulted in a Japanese family court, a court in Japan actually issuing a child handover order to comply with that international legal reality. It shows that even when a mother feels justified by, traditional Japanese norms, the courts in Japan are starting to recognize the other country's legal claim.
That Fukuhara Ai case is a perfect transition because it raises the question, What was it in the Japanese law that made her feel she could act that way in the first place?
Mhm.
Let's do a deep dive now into the specific mechanics of that traditional system, the single custody rule, and all the administrative problems tied to it.
Okay, so we have to talk about the koseki, the family register system.
Right.
Under that old single custody framework, only one parent gets legal custody after the divorce. But this often didn't line up with the koseki.
How so?
Even if the mother is granted physical custody, the children often remain legally attached to the father's koseki. So the father, just by being the listed parent on that register, he still has the legal right to request the children's juminyo.
Their official residency record.
Exactly, from any local government office.
So how does that specific loophole allow an abuser to track a victim?
Well, the koseki isn't just a record of where you live. It's the primary legal document for lineage, for family relationships. Because the ex-husband is still the legal father on that paper, he can legally ask where the child and, by extension, the mother is living.
Wow. So that single custody system becomes a massive, potentially fatal security risk for domestic violence victims who have fled.
It's a huge risk.
And that risk has forced the state to step in with something called DV support measures. Can you walk us through how that system is supposed to work and, where the failures are that have put lives at risk?
Sure. The DV support measures were designed as a safeguard. When a DV victim flees and registers their new address, they can tell the local government office that they're under threat.
Okay.
This should put a permanent alert on their file, restricting anyone from getting their juminyo or other residency data, specifically the registered abuser, regardless of that koseki link.
So where does it go wrong?
The failures are unfortunately operational. We've seen specific reports where local government offices, maybe due to staff overload or lack of training or just simple human error, they mistakenly process the ex-husband's request.
Without checking for the DV alert.
Without checking. And then that information, the exact address of the mother and child, is released to the very person they're hiding from. It just goes to show how fragile the protective system really is.
That choice facing a DV victim sounds impossible. You're trading legal stability for physical safety.
Precisely. It's a terrible trade-off. The only permanent way to cut off that koseki security risk is for the mother to completely remove the child from the ex-husband's register.
Severing that legal link.
Right. That's what grants the father that administrative access. But here's the cruel twist. Taking that final legal step can create new, profound financial challenges. By hiding the official legal relationship, the mother often makes it extremely difficult, if not impossible, to enforce child support payments later on.
So they're trapped.
They're trapped in this complex administrative knot, constantly choosing between immediate safety and long-term financial stability for their kids.
Okay, let's shift focus now to the big international mechanism designed to solve these conflicts. The Hague Convention on the Civil Aspects of International Child Abduction.
Right, the Hague Convention. It was established way back in 1980 to create a unified system to ensure the swift return of children wrongfully removed from their home country.
It's meant to prevent exactly this kind of unilateral child-taking we've been talking about.
It is.
So it's pretty staggering that when our sources first looked into this around 2010, Japan still hadn't ratified it.
No, it took a very long time.
I mean, Germany ratified in 1990. Japan didn't ratify until 2014. For decades, the country was just legally isolated on this critical humanitarian front.
And even after they ratified it, implementation is still contentious, especially with DV cases, which, as we said, often motivate the mother's flight in the first place.
Because the Hague Convention has a really strict standard,
A
right?
very strict standard. It only allows for refusing a child's return if there's a grave risk that the return would expose the child to physical or psychological harm. That's Article 13, and it is a very, very high bar to clear.
So what does proving grave risk mean in practical terms?
Yeah.
For a victim, a mother who's just arrived in a foreign country, trying to navigate a whole new legal system.
It means the entire legal burden of proof falls on her.
On the parent who fled.
Yes, usually the mother. She has to prove this grave risk exists, often in a court that's using a language she might not speak, cut off from her support network, relying on translators, and often, not enough legal aid.
That sounds almost impossible.
And the court's focus under the Hague isn't even on proving the past abuse. It's on proving the risk of return. If she fails to provide enough legal proof that the child is in immediate danger now, the child may still have to be returned to the alleged abuser. It's a process that often re-victimizes the parent who's trying to protect their child.
And that kind of legal isolation, that vulnerability, it drew some serious international fire. I mean, we saw the diplomatic pressure really boil over in 2009.
Oh, yes.
When ambassadors and ministers from 8 countries, the US, France, the UK, Canada, Australia, they took the highly unusual step of publicly demanding that Japan join the Hague Convention and make real reforms.
A joint public statement like that is a huge diplomatic move. It's basically forcing the issue into the open.
So why such a unified public outcry?
Because Japan's lack of cooperation was creating a kind of legal black hole, it was functionally shielding its own citizens from international law, and in doing so, it was violating the parental rights of citizens in those other 8 nations. It became a crisis of sovereignty.
And sadly, the cost of these systemic failures can be measured in profound tragedy. Our source material brought up a heartbreaking recent event, the murder of a Japanese woman in Hungary just in January of this year.
A truly awful story.
Just a horrific cost. What does the source argue was the specific legal mechanism that left her trapped, that made her so vulnerable in Hungary?
The context is everything here. She was trying to get back to Japan with her child to escape domestic violence.
Okay.
But because of the joint custody laws in Hungary, which, unlike Japan's old system, need both parents' consent for administrative stuff, and because of the Hague Convention, she couldn't get a passport issued for her child without the father's consent.
She was legally neutralized.
Completely. She was unable to get the travel documents she needed to get her and her child to safety. She was trapped in Hungary, isolated and vulnerable.
And the source material argues that this tragedy was, fueled by inadequate Japanese support.
Yes, inadequate Japanese support systems and a fundamental lack of understanding of DV dynamics in an international context. The fact that she was blocked administratively from traveling to safety just highlights this huge disconnect between policy and survival.
So where does this all leave us for the future? Thankfully, there is movement. The proposed 2026 introduction of joint custody is progress. It's a long overdue step.
It is, but the sources are emphatic. It is not enough on its own.
Right.
The policy recommendations have to go deeper than just changing the name on the custody arrangement. We need multicultural counseling. That's absolutely essential, especially as international marriages keep rising.
And we keep circling back to financial stability. What about child support enforcement? That seems to be the critical trade-off for DV victims. You mentioned the My Number system could help at this, so why is that stalled?
Well, effective enforcement is technically possible. You could link it to the My Number national ID system, allow for automatic wage garnishment. But it's been politically stalled.
Why?
The resistance comes from institutional and political groups citing privacy concerns and, as the source materials note, a resistance to reforms that might disproportionately disadvantage men. This is partly attributed to male dominance in institutional decision-making.
I see.
So a key requirement is to prioritize enforcing those payments so that safety doesn't mean poverty. And another thing, we need mandatory child consultation by a third, neutral party in these disputes. The child's voice has to be secured.
And this sounds like it needs comprehensive, linked action across government agencies, not just in the family courts.
Absolutely. Greater institutional cooperation is non-negotiable. You have to link the Ministry of Foreign Affairs, which handles the Hague Convention cases, with the family courts deciding custody and the NPOs who provide the on-the-ground support. Without that coordination, the system is just a patchwork that fails people who fall through the cracks.
This has been a heavy but really necessary deep dive. Law, culture, tragedy.
My final thought on it is this. This issue goes way beyond a legal debate about who gets the child. It's a complex knot of law, of entrenched cultural isolation, the reality of domestic violence, gender politics, and this fundamental challenge of making 2 different legal systems work together.
One that guarantees a parent the right to flee danger, and one that guarantees the other parent the right to access.
Exactly, and trying to make them coexist while protecting the child above all else.
So our critical takeaways for you are clear. Japan operated in legal isolation for decades, creating a system where taking a child felt justified at home but was criminal abroad. DV victims often pay the highest price, forced to choose between their safety and financial support. And the challenge now is making sure the new joint custody law is matched by equally robust, functional, and culturally aware support systems.
And here is a final provocative thought for you to consider. Japan is actively trying to increase the number of foreign workers and immigrants. This will inevitably lead to more international marriages and, sadly, more international divorces.
Well.
So the question is, how quickly must the legal system and social support structures adapt to truly ensure the best interests of the child are prioritized across all these different cultural and legal frameworks? The speed of this adaptation has to be far faster and more comprehensive than the generational changes we've seen so far.